What if you pass away without a will? So if you pass away with no will in place, state law fills in the gaps. State law dictates who gets what if you haven't clarified in a will who your heirs or beneficiaries are. So those of you in the Virgin Islands law dictates who your beneficiaries will be. Your beneficiaries are those people who are going to inherit your assets when you die. So if you die without a will, state law tends to follow what you might expect people to choose. For example, most states, and including the Virgin Islands, a surviving spouse is the primary heir, and then your children after that. If there are no spouse and there's no spouse and no children living, then it goes to your parents who would receive your estate. And then ultimately your siblings and nieces and nephews until someone in your family is available to receive your estate. But it can get really tricky if you have a blended family, or either you or the surviving spouse have children from a different relationship, because the numbers get a little tricky and your family doesn't just inherit 100% of your assets or in equal shares, 50-50, or in the third, depending on how many in your family has survived you. So while New York law, US Virgin Islands law, and Florida law, for that matter, fills in the gaps to make sure that people who are close to you receive your estate, it might be different from what you would want. So it also doesn't clarify who is in charge of the assets left to a minor or an incapacitated beneficiary. State law is really just following the family tree, but really doesn't do a whole lot more than that to make sure that those who do receive your estate receive it in the way that you would want, and maybe at specific ages along the way. For example, you may not want a minor child receiving your assets, your estate at the age of 12 versus the age of 18 versus the age of 25. So you may want to have specific ages that of a beneficiary who's a minor at what time in their life that they would benefit and receive your assets. So if you die without a will, state law fills in the gaps. But even then, it really is important to make sure that your plan is laid out in writing, so we're not having to rely on state law for you.